good evening. Hopefully my audio is coming through well and everyone can hear me. I'm going to go ahead and get our virtual panel started. We wanted to give a few minutes for people to come in, but we'll still have some people trickling in throughout. So I want to say good evening. Thank you for joining the Maryland Center for History and Culture for tonight's virtual program. My name is Chloe Green. I serve as the Public Programs and Outreach Manager here at MCHC. You probably got so many emails from me with so many Zoom links today, but if not, lovely to meet everybody. I'm also hosting this evening's program, our virtual panel, the Francis Scott Key Bridge, Dali, and Maritime Law. So this program is being recorded and will be made available for public viewing on our virtual program archive in the weeks following, which that link will show up in our chat in just a little bit. And this Zoom webinar is equipped with a Q&A chat function. The button is located next to our chat, like the actual chat button. So if you have questions or comments for our panelists, please use this Q&A chat function, and we will reserve time at the end of the program for your questions. So to kick us off, I am going to introduce our panelists for the evening. I'm very honored to be welcoming such an accomplished and knowledgeable group of professionals to this program. And for the sake of time, I'm going to give a very condensed version of our panelists' biographies. So I'm only scratching the surface of all the great work they've done, but I just wanted to note these are some very fantastic people we're welcoming in tonight. So to begin, I want to give a warm welcome to our moderator, Kate Livie. Hi, Kate.
Hi.
So Kate is a professional Chesapeake educator, writer, and historian, an Eastern Shore native. Kate is passionate about the Chesapeake Bay's culture and landscape. She is an active commentator on Bay culture and environment, writing about the region's history, foodways, travel, and traditions. In addition to her writing career, she currently serves as Chesapeake Studies faculty at Chestertown's Washington College, where she teaches about the Bay's environment, culture, and heritage. Kate is also the founder and head creative at Alosa Communications, and Kate can also paint a house for you if anybody really wants that to happen, because she's got side hustles.
It's true.
Thank you for being here, Kate.
Happy to be back. Thanks, Chloe.
So next I want to welcome James Jeffcoat. So James, feel free to hop on screen with us when you can. There he is. All right. So James was born and raised in Maryland and grew up in and around small boats. He went to college at Maine Maritime Academy and sailed in both unlicensed and licensed positions aboard U.S. flag merchant ships in the Gulf of Mexico and on coastwise and foreign voyages. He holds a 1,600-ton master's license. James attended University of Baltimore School of Law and currently practices in maritime law, hence why he's with us this evening. In his free time, James loves being on the water anytime he can and teaching sailing to the next generation of boaters. So thank you for being here, James. So next we have Bill Kamala. So Bill, if you wouldn't mind waving so the folks know who you are. All right. Hi, Bill. So local to the Baltimore area, Bill lived overseas in Germany as a student from 1959 to 1960 and on business in Australia from about 1970 to 1971. He has 27 years of experience as the regional sales manager for several foreign flag ocean carriers covering territory from the New York state line to Tobacco Road in North Carolina. And Bill is retired now, so hopefully the retirement life is treating you well, Bill. Thank you for being here.
Thank you, Kate.
Yeah. And last but certainly not least, we have James Jimmy W. Constable. So Jimmy, if you want to give people a way to see who you are. So Jimmy is a graduate of the University of Virginia and the University of Maryland School of Law. After clerking for a judge on the Maryland Court of Appeals, now the Supreme Court of Maryland, he went into private practice and has been with the firm Wright, Constable, and Skeen since 1969. His introduction to maritime law came from his representation of railroads, frequently brought into maritime cases as being a leg in the transoceanic shipping. Many of Jimmy's cases have dealt with collisions, which is a new term I learned today, freight loss and damage, maritime liens, and a variety of other issues. So thank you all again for being here. Hey, thank you everybody for joining. I hope you have a wonderful conversation. Kate, I'm going to pass it to you.
Here we go.
I'd like to introduce myself as I am a Chesapeake historian, a maritime historian, but this is certainly not my area of expertise. And I think there are a lot of people on this panel tonight who are excited to learn more about kind of the complexities of this case. It does seem relatively straightforward, right? So on March 26th at 1:29 a.m., the container ship Dali struck the Francis Scott Key Bridge and caused it to collapse into the Patapsco River. This collapse killed 6 bridge workers who were working, on bridge construction. And for most of us, like me, I'm sure you woke up the next morning to clips of the Key Bridge collapsing over and over and over, news headlines everywhere, but it still seemed relatively straightforward, right? A ship crashes into a bridge collapses, and then you have the environmental disaster that ensues, the loss of life, and of course, the Port of Baltimore's closure. But this relatively straightforward from an onlooker's perspective is actually quite legally complex. And so here today, we've assembled this panel to dig into the kind of the meat of this particular case and help us understand not just why it is so complex, but how that complexity is really represented by kind of the historical precedent and context that our panelists are here to explain tonight. So I'd like to go ahead and get started by just pitching a question to the three of you, which is, I'd like to know just a little bit more background on the Dali in particular.
I guess, thank you, Kate. Good evening to everyone attending. I've been asked to recite the details of the ship, the motor vessel Dali. But allow me to say, I have not worked as a pilot, nor have I been a loadmaster or a longshoreman or an investigator. I'm a salesperson. Having spent several decades in ocean transportation, I've been on many ships, stood on the bridge, observed stevedore loading of ships, and often explained the process yet to exporters and importers. I'm not an attorney. So, yeah, in the conversation, we have to trust that the owners or the shippers of the cargo loaded their containers properly. We have to trust that the stevedore loaded the cargo of the ship properly. With this all understood, the MV Dali departed Baltimore Seagirt Marine Terminal about midnight on March 26 of 2024. Please note the following details about the Dali. She was built in 2015 by Hyundai Heavy Industries in South Korea. She's registered in Singapore. The vessel was owned by a Singapore firm, Grace Ocean Private Limited, and which that company owns about 55 ships. The vessel was operated by a Singapore firm called Synergy Marine Group. The vessel was flagged in Singapore, so therefore it's not a flag of convenience in another country. It is a classification. It's been classified by a society.
And so just for those of you who may not be familiar, the term classification society refers to private entities which undertake to confirm for various flag states like Singapore or the United States. They go on board ships because the Coast Guard or the equivalent in Singapore, for instance, doesn't have the manpower to go on every single ship and make sure that we've got the right manning, the right equipment, and everything's up to snuff. So these classification societies hire folks to go aboard the ships, and then they confirm to the authorities that, yes, the ship complies with applicable regulations. And the classification society, as Bill was saying, for this ship is called Class NK.
I think actually changed. They write regulations as well.
I'm sure that they have a heavy input in terms of the regulations. Yeah, they've got a lot of in-depth knowledge for sure.
Yeah.
Okay. All right. Also, the ship is rated for 9,971 20-foot equivalent units. That stands for, you really abbreviate it to TEU. That's the way to judge the size of the ship. She's 984 feet long, 158 feet across, and will go to a 50-foot draft. She's 95,128 gross tons and will displace 112,363 tons. At the time of her time in Baltimore. She was carrying 4,680 containers on board. That's not TEUs, but the number of containers, both 20s and 40 foot, and which many were empties being repositioned. The main engine is a single slow speed diesel of 55,626 horsepower. Imagine that at Daytona. There's other diesel engines that also power the generators, which in turn power lubricating pumps, water cooling systems, and the steering rudder. Please take note of that point about the rudder. The loss of lubricating or cooling systems will cause the shutdown of the main engine. As a comparison, the larger size container ships today now on the ocean can be 20,000 20-foot equivalent units. I've actually have heard of 22,000 equivalent units. So that would mean, about 1,300 feet long and 200 feet across, with also a 50-foot draft. So the largest oil tankers today now are 1,500 feet long. In July of 2016, there was an incident at a berth in Antwerp. In June of 2023, there was a deficiency concerning propulsion and auxiliary machinery, which was reported. That includes the gauges, thermometers, and such by Chilean authorities. In September of 2023, the U.S. Coast Guard inspected the ship at the port of Newark. But there was nothing was made of any deficiencies. In 2016 and 2023, reported instances do not appear related to the Key Bridge disaster. As a final note, there was a crew of 21 crewmen plus 2 pilots, so 23 people on board. The Dallas draft at the time she sailed from the port of Baltimore was 39.9 feet in a 50-foot channel. So, Jimmy, you've got something you want to add here?
Well, let me set the stage. This is a very rudimentary diagram of the electrical system. If you can read it, you'll see at the top you've got 4 diesel generators. Combined, they produce 6,600 volts. And there are 2 buses that go down to 2 separate transformers, reducing the voltage to 440 volts. And you'll see on the diagram there's circuit breakers, 4 on each side. So the system has built-in redundancy. In theory, if you'll only have one side, either HR and LR1 or HR and LR2 going at any one time. And if the one that is in use ceases to function, which it did through a tripping of the circuit breaker, then the other could go on automatically if it's set to do that. Otherwise, it's got to be done manually, which takes time. If all power is lost, then you lose the cooling system, you lose lights, you lose the lubrication system, and the engine, the main engine, will cease to function, which is exactly what happened. There is an emergency generator that does come on automatically, and it did in this case. The fuel system there are three different ways of fueling the diesel engines and the main engine. There are booster pumps, which are pretty big, powerful, have high capacity. Then there's what's called a flushing pump, and that's used primarily to flush the fuel lines when fuel types are being changed because of different regulations in different countries. It is not really intended to be the main source of fuel, but apparently we're hearing that this ship was using it because it saves some money. Then there's a pneumatic pump that is, the word pneumatic means basically air in this case, air pressure pump. Very limited capacity, but it has some capacity. So we start off at 12:45 on March the 26th.
Jimmy, can I interrupt just slightly?
Yeah.
So I think what you're getting to, and thank you, Bill, for setting the stage with giving us a rundown of the Dali. I actually recently heard it described and that the length of the vessel is equivalent to the height of the Eiffel Tower, which I think helps people understand the sheer size of this vessel. And the electrical diagram I know is already giving me a sense of foreboding, because it doesn't already have a sense things aren't going to go well there, and we know they didn't. But I'd appreciate it. I think, Jimmy, if you could walk us through kind of step by step the events of that night, March 26, 2024. And it's a dark, cold spring night, it's departing with all of this cargo that Bill has described. So take it away.
The vessel gets underway from the secret marina destined for Sri Lanka at 12:45 on the 26th. Generators 3 and 4 are supplying the electric power. Those you saw in the diagram. They were two on the left-hand side. They're supplying the cooling, the lubrication, and the lights. As mentioned by Bill, there's a senior pilot and an apprentice on board, and they conversed prior to takeoff, and the master told the pilots that everything's good to go, everything's in order, which it may not have been. At 1:08, the tugs are released and the Dali is on its own. And then at 1:25, which is only 4 minutes prior to the elision, breakers HR1 and LR1 trip, and there's a blackout. If the system had been set up on automatic, HR2 and LR2 would have automatically gone on, and there wouldn't have been any interruption. But they were on manual, not on automatic. So this caused the loss of the cooling, the lubrication. The engine was off, automatically shut down. No propulsion, no rudder, no flushing pump, and the fuel system was relying only on the pneumatic pump, which came on. The voyage data recorder went off. It's dark. They're running around. Time is, ticking away, and they get it on manual eventually. The pilot at 1:26 and 13 seconds, he orders the rudder 20 degrees to the port. The emergency generator comes on right after that. It takes 60 seconds to get that going, not enough time to allow the rudder to move. The regulations say it should take 45 seconds, so there's a breach of regulations. The breakers at HR1 and LR1 are then closed and power is restored. That took 60 seconds as opposed to the 45 seconds that the regs require. At that point, just a few seconds later, the pilots call for tug assistance, but the nearest tug is 3 miles away, so that's not going to do anything. At 1:27, the pilot orders the anchor dropped that is not effective. And then a second later, there's a second blackout, mainly because the fuel system is relying on the pneumatic pump, which is just simply inadequate. Even though the diesel generators are running, there's no power available for the main engine. It is not restarted. So at 1:27 and 23 seconds, no propulsion, the pilot orders rudder hard to port. The rudder is not effective. 2 seconds later, the pilot warns the waterborne traffic that there's a problem. At 1:27 and 32 seconds, the breakers are restored, but the propulsion is not regained. And the pilot orders the port thruster to be implemented. The port thruster would swing the valve to port, but it didn't work. So that wasn't any help. And then at 1:27, 53 seconds, the MTA closes the bridge to traffic, which was heroic and saved God only knows how many lives, people that could have been driving across that bridge. And then at 1:29, traveling about 6.5 knots, it strikes Pier 17 of the bridge, and the bridge collapses, killing 6 workers, 2 survived. It injured 1 or 2 people on board the Dali. It's one of the largest maritime disasters of our time, and absolutely no way to measure the ripple effect on the damages that it caused. So,
Jimmy, a quick observation. It appears that from the timestamps on your timeline, we're talking about a disaster that occurred really in a 4-minute window, which is incredibly short. So it's remarkable how much happened in that amount of time, but also that the bridge was able to be closed. That's really incredible.
well, Kate, imagine you being on that vessel, and after the first blackout, it's dark, you can't see. And really, after the second blackout, it's dark, and you're scrambling around, you're trying to do things manually. And to do it manually, you may have to go to different rooms to pull different switches. It must have been an absolute panic. I'm amazed that they actually were able to do what they tried to do. It just wasn't successful.
And you know, I think one thing to note that is, in my view, and I think echoing what others have said, is really pretty impressive, is that the Maryland Transit Authority police were able to close the bridge, and not, of course, to diminish the loss of life, but my understanding is that one of the primary reasons they were able to close the bridge so quickly was that not only did the pilot think to call the pilot dispatch office and advise them that this was unfolding, which is kind of crazy that they were able to do that this quickly. So then the dispatch office calls the Maryland Transportation Authority police. But
Within 2 minutes.
Yeah, and as you said, Kate, you know, all of this is unfolding in 4 minutes because these construction workers are actually out on the bridge. The bridge is only open for one-way traffic, and there are already police officers stationed at each end of the bridge. You know, again, not to diminish, but I think it's pretty clear that this disaster would have been much more catastrophic from a loss of life perspective had those police officers not already been stationed there, and had it not happened at the time that it did in the morning. So it's all pretty outstanding, you know, what the pilots did and what was done on such a quick basis. And the crew did too, do some, you know, they were able to get the power back on even though things were not set back in automatic.
Well, they never actually got I think actually they might have gotten the main engine running.
My understanding, at least from my read of the NTSB reports, I don't think they got the main going
They didn't
again.
get it going.
The diesel generators, you know, to run the
Just
auxiliary
one power
systems
pump.
got back online, but not the main.
At any rate, they had no rudder,
Yeah.
and no effective propulsion.
And so, Jimmy, sort of, you know, jumping on top of what you said there, you know, there's a current litigation that's ongoing. We'll talk more about that as we go on here. But I think one of the most helpful pieces of pleadings in the litigation to read, to really grasp the facts. And Jimmy did a great job, but there's a ton of facts here, and they're very detailed. And so the Department of Justice has filed a claim in this action. And in my view, kudos to whoever, the group of people that wrote it at DOJ. I think they just did a really fantastic job. It is one of the pleadings that most clearly outlines, in a very detailed fashion, but very understandable, exactly what was happening and how it was happening.
Yeah, the one thing that they had as their advantage was that there was a black box on board that recorded all the transmissions, all the orders.
Right. Yeah. So on modern day ships and modern day commercial vessels, there's a requirement for what's called a VDR, a voyage data recorder. And Bill, that's what you're talking about. And it's like he said, equivalent to the black box on a plane. It's not quite as sophisticated, but it's recording all the audio that's going on the bridge, and having listened to them, it's not crystal clear, but they're pretty good. I mean, they pick up quite a bit. They also record lots of information about the ship's heading, speed, etc. Their ships are using what's called electronic charting displays. The VDR records that. It records the radar, etc. So that there's a button you push after a casualty like this, and it's captured. And so that is definitely one of the things that is getting intense scrutiny by both the investigations that are going on, and there's at least 3 investigations. There's the NTSB, there's the Coast Guard, and then the FBI is involved, which suggests they're considering, whether there's any criminal element to what's going on here. So certainly those investigators are going to be heavily scrutinizing that VDR. Similarly, I mean, the ship was built in 2015, so she's a relatively new ship, and that's going to mean that there's a lot of automation in the engine room as well. And so there's going to be a lot of electronic crumbs for the investigators to investigate and to use to determine the timelines. And I think a lot of that is borne out in the NTSB report, and also these DOJ allegations. Personally, I would characterize the DOJ allegations as explosive in some regards. It is certainly it's advocacy. There's a lot of discovery to come. Into the DOJ allegations, but for instance, the DOJ alleges, which a lot of this is consistent with the NTSB, that there were long known vibration issues on the vessel, and that these were causing issues with ship's equipment, including the ship's electrical equipment and the electrical buses, which are like really big breaker panels, like stand as high as a room breaker panels, but that they were causing these vibration issues had been known by the vessel and potentially by the vessel owner and operator to be causing damage to ship's equipment. There are pictures in the DOJ complaint of what they refer to as jury-rigged vibration dampers. And one of them, I think that's fair. One of them is a piece of cargo lashing that has been welded to a bulkhead and then to this electrical bus, it looks like. But I think what's important about, or what's telling about the DOJ allegation is it says that the dampers themselves, the welds had cracked and been re-welded, which indicates that it's an ongoing and perhaps known issue there. So that's a pretty important fact. The DOJ also alleges that the vibration issues were so significant that they were known by at least the chief officer, that's the international parlance, or the first mate who deals with cargo operations on a vessel. The chief officer had reported as he was being relieved by another chief officer that the vibration was causing the cargo lashings over the engine spaces to loosen up much more quickly than the cargo lashings around the rest of the ship. Again, which signifies that this is an unusual and significant issue. There's additional allegations that there were a lot of loose nuts, bolts, wire ties, and other debris basically within the electrical buses. Again, which may suggest that people were in there working, or it may suggest that the people that were in there working didn't clean up well after themselves. Again, there'll be a lot of discovery about, what the facts are there. Another thing that was interesting to me was that DOJ alleges that there was an independent agency who was on board during some of these investigations doing testing, and they stopped the testing due to safety concerns. It's a little bit vague to me based on my reading exactly what those concerns were and whether they relate to the issues that caused the elision here, which elision is a word that we use in this context. It means when a moving object hits a fixed object. So it's like collision, but elision.
Got it.
So again, the DOJ has snips of reports about these vibration issues, one of which indicates that they were actually reported to the vessel owner. I'm sorry, not the owner, to the vessel manager, which is a company hired by the owner. But again, that's significant in terms of privity and knowledge, which is a concept we'll come to later. Sorry, Bill.
You want to go into limitation of liability?
Well, first, I just want to say that, it's what I'm gathering here is this much fuller picture of what happened, right? We've gotten this kind of minute by minute, second by second unfolding of how, the vessel was, losing power. We're in the darkness of this cold Port of Baltimore, heading out into the Patapsco. The tugs are too far away to help. The vessel alludes with the bridge, but then you also have this sort of the things that are coming out now about the condition of the vessel itself, and that there's some pretty damning evidence that suggests that this is not even though it's a relatively new vessel, it's not in particularly good condition, which is all sort of stacking up to lead me to ask, you've got this vessel that is in need of repair, is being operated anyway, in a way that, even the DOJ is saying is sort of jury rigged. So who's at fault? Is it the vessel operator? Is it the vessel owner? And then who pays?
Well, that's a good question.
That's the occasion for the attorneys to resolve.
Actually, Kate, the vibration, it's sort of like have you ever driven a car with unbalanced wheels where you get to 50 miles an hour and then the car starts shaking and then you get to 60 and it stops shaking? Mm-hmm. That's apparently how this worked. When the engine reached a certain RPM rate, it would vibrate. And as James pointed out, they knew about this because they tried to stop it with this jury rigging. But let's get down to who pays what, to put it in normal terms. Back in 1851, imagine the United States in 1851. You didn't have steamships. You had some paddle wheelers, but I don't even think the screw propeller was invented until 1838 or something like that. You didn't have any radios. You didn't have any GPS. You didn't have any way to get weather reports when you're out there. You couldn't communicate with other ships if there was trouble. You're at the mercy of the wind. So you're either becalmed, or if you were trying to escape a pending hurricane, you are at the mercy of the wind. You may or may not be able to do it. The stakes were pretty high for these ships, because if a ship went down, all the cargo was lost, there could be a huge liability. So in order to incentivize United States business people to get involved and invest in shipping, they passed the Limitation of Liability Act in 1851. And what it basically says is the owner of the ship, of the vessel, can limit the liability to the after value of the vessel. That is, after the elision in this case, or if it sinks, after it sinks. And a typical example is the Titanic in 1912. When the Titanic sunk, the owner sought limitation of liability. The value was something like $92,000, which was the value of the lifeboats. And that was about it. And that had to be shared by everybody. I mean, there are other terrible examples. Remember the dive boat that caught on fire in the Pacific several years ago.
Conception, yeah.
Yeah. I just finished a book about a number of fairly substantial steel boats, or ships in this case, that would net Alaskan king crabs in the Bering Straits. And they were not very stable. They were overloaded, they were not loaded properly, and the storm would come up and they'd turn over and sink. And there's a great deal of controversy about that because everybody would be lost and the owner would claim limitation of liability. So it's a very controversial act right now, and I think we'll be talking about some changes. But as James pointed out, if it can be shown that the owner, and in this case, Synergy would be considered part of the owner because they're the manager, knew or had privity of knowledge that there was a problem, and it is the problem that caused this elision, then unless the act of the owner was intentional, which in this case nobody's claiming it was, even if it's negligent, liability can be, the limitation can be overlooked if you can prove the privity and knowledge. And it's got to be fairly high up. It can't be the captain, it can't be the pilot, it may not be the port captain. It should go up the chain fairly high up.
Into management.
Into management, and that's going to be a big issue in this particular case, exactly how far up it goes. James, why don't you go through the procedure of how that works?
Sure. And one thing I'd like to touch on, because, I think for a lot of us, for me, certainly when I first learned about this procedure in general, the idea that a ship can just, limit its liability to the after the accident value of the vessel and her pending freight is kind of a, strange, it sounds strange. But as Jimmy was saying, this is intended to encourage maritime commerce. Another thing to me that Jimmy was just touching on is how high up the chain this privy and knowledge concept gets to. The idea to me at first blush that even if the master knows about an issue, which ostensibly one would assume that the master would know most of what's going on a vessel, even if the master knows about an issue, it's not necessarily attributed to the company, the owner, in terms of breaking the limitation. And initially you think, well, how is that? The master knows, then the company should be charged with that knowledge. But if you think about the limitation of liability concept, you have to, again, like Jimmy said, you have to put yourself back in 1851, where there's a lack of communication between the owners and the master throughout, most of the voyage. So it feels maybe unfair now where there's satellite phones and email every day and all this communication with a vessel, but at the time, conceptually, that was one of the policy reasons why it was decided that just because the master knows, it's not necessarily attributed to the vessel. So shifting gears just slightly here to the procedure, the way this works and the way it worked in this instance was that Grace, the owner, and Synergy, the vessel manager, filed a petition to limit or exonerate themselves from liability. They filed that 7 days after the incident. again, not surprising, they're going to take advantage or try to take advantage of this law. There's going to be a fight as a sidebar about whether Synergy is able to claim limitation of liability. The statute uses the word charterer. Synergy, to my understanding, is technically operating this vessel under a vessel services agreement, which is not an uncommon arrangement, but it doesn't necessarily make them a charterer. So you'll see in a lot of the pleadings that there's already a fight going on and brewing about whether they're going to be able to limit their liability. But so the owner and the charterer, and perhaps in this instance, we'll see Synergy filed a petition and said, we think the post-incident value of the vessel is $43.7 million odd, and they have to then post security in that amount with the court. And that security actually bears interest at 6%, which is no chump change on $43 million. But obviously, in consideration of a bridge that's going to cost $2 billion, the DOJ complaint claims a little over $100 million, and that's just related to the cleanup costs. So certainly 43 million is not going to be enough. So they filed this petition. The court then, once the court accepts the petition, accepts the value that the petitioner submits, and confirms for itself that the security is sufficient, then the court will issue an injunction against any other litigation outside of this forum against the vessel arising out of this context. There's some limited exceptions, but as a general proposition, every claim against the vessel arising out of this elision has to be brought now in federal court under the court's admiralty jurisdiction here in Maryland, and it's located in Maryland because that's where the ship was when this accident happened. The court then sets a deadline by which claimants have to file claims. And, that's anybody who says, hey, I was injured as a result of this elision, this accident. You've got X number of days. In this case, the deadline was September 24th of this year to file claims. There were some minor exceptions that the court made, but pretty much everybody filed by the 24th. The injured parties, then they file claims saying, here's how I was damaged, and they also have to answer the petition. The injured parties do have the ability in the litigation to take discovery on and fight about whether $43 million is correct, whether that calculation is correct or fair. One of the other things that's, I think, fascinating about this limitation of liability action is that it's a bench trial, meaning there's just one judge who's going to decide at the trial level whether there's going to be exoneration. In other words, the vessel's not at fault at all, or whether there's going to be limitation. In order to get to limitation, first the claimants have to prove that there was negligence or unseaworthiness of the vessel. Then that burden would shift to the owners to show that they did not have privity or knowledge at a high enough level to be charged with privity or knowledge. If the court finds that that's true, the court would uphold the limitation, and the claimants, all of them, would be stuck pro rata sharing in that $43.7 million. Now, the statute has an equitable increase. It's very complicated. That has to do with personal injury claimants. So those claims are handled a little bit separately. But suffice to say, if limitation is upheld in this case, there's no way that anybody who's a claimant is going to get anything like a recovery that's the value that they actually lost.
So that all happens in one decision, James?
So what the court will do is the court will split the case into two phases. The first phase, and this is typical in a limitation action, and Judge Berdar, the judge who's handling this particular case, has indicated he's going to do it here too. The first phase of the limitation action will focus on this idea of, was there negligence or unseaworthiness? If so, was there privity and knowledge? And therefore, is their limitation going to be upheld? Then once that is decided, there would be, in theory, a separate trial on damages. Who's got priority of claims? How much can they prove, et cetera? if the limitation is broken, if there's privity and knowledge and the limitation is broken, then all the claimants can submit and try to prove all of their damages and recover all of their damages against the defendants.
James, I had this back in the 1970s when the vessel coming through the C&D Canal collided with the railroad bridge. That the railroad bridge would go up and down depending on where the train was coming, and it was down when it should have been up. And the vessel came through the canal, and unfortunately, one person died. It destroyed the bridge and did a great deal of damage to the ship. And we have these very same issues, and again, it was bifurcated. Damages were decided in a separate trial. In that case, we settled it. Let me get into the other area that limits liability. You can imagine, I mentioned the ripple effect of the damages. Obviously, the ship was damaged, the bridge was damaged. People lost their lives. It's going to cost a lot to fix it. There's going to be a lot of contracts to repair things. But it also stopped the traffic up and down the bay. So you have an interruption of the supply chain. It caused a lot of people that couldn't use the bridge to detour around. There were an awful lot of indirect expenses. And you can just keep going back and back and back, to the family in Richmond that couldn't get their Cheerios or something. And in 1927, this issue and the problems was tackled by the Supreme Court in an opinion called Robbins Dry Dock and Repair versus Flint, 1927. And it was an opinion written by Justice Oliver Wendell Holmes, one of the icons of our judicial history, who was also famous for saying in judicial navigation, logic is a poor compass indeed, which I loved and very fitting, but it was not a maritime case. And he said that I think he was after the Internal Revenue Service at the time.
Story for another day.
So what it does is it limits the claimants to those who were in actual possession and control of what has been damaged, or they've got the responsibility to repair it, or the responsibility to maintain it. It's sort of a tripartite test. It doesn't matter about foreseeability of the injury, the proximate cause, it was a proximate cause, actual knowledge, anything like that.
And sorry to jump in here, Jimmy, but so I think one of the reasons Jimmy mentions it doesn't matter about foreseeability, or this term called proximate cause, which is kind of a rough justice way of saying foreseeability. But the reason Jimmy's alluding to that is that in the law, one of the ways that tort liability for accidents essentially is limited in many other instances, in many other contexts, does rely on an analysis of foreseeability. That is not the premise of the Robbins doctrine, which Jimmy is explaining here. So it's important because it's a different way to limit the liability.
So yeah, thanks for clarifying that, James. Those people who can make a claim under Robbins, the crew, the ship, the cargo owners, those involved in salvage, the tugs, the agents, brokers, sellers of supplies. Those are just examples. The owners of cargo, the lessees, the buyers, land-based interest damaged by the elision, and contracts related to them, those who have the duty to repair. But the more remote types of damages just cannot be allowed under Robbins. And it was written that way to sort of give some sort of a bright line, easy rule for determining who can make a claim. Otherwise, it would be endless. And to avoid a flood of litigation. And to be fair, because if you have everybody, even the most remote claimants, there would be nowhere near the amount of money, and it would place a huge burden on one party. And as a matter of public policy, that party, the ship in this case, is really benefiting society in actually being in that business. And there are also alternatives, insurance and contract alternatives to help with these claims. Bill, do you want to talk about general average?
Sure, I can define it here. General average is applied.
Oh, can I tell you the history of general average?
Sure.
Yeah. About 2,000
You
years
want to
ago.
read it?
About 2,000 years ago, in Greece, the shippers, you can imagine them either rowing or sailing with their cargo and their friends and colleagues' cargoes across the Mediterranean and running into a storm. And the ship might sink, so it's too heavy. They need a little more freeboard. So they take James's cargo and they throw it overboard. And they take Bill's cargo and they throw it overboard. And the ship is saved and everything's fine. Well, James and Bill complain. They say, wait a minute.
Jimmy's cargo didn't get thrown overboard.
My cargo is safe. That's not fair. And,
Well, it's my ship, so.
and that is the origin of general average. There you go.
Yeah,
Bill.
okay, well, wonderful, thank you. I can throw this away now. All right, okay. Now, general average has been declared by the owners of this ship. And just to give you a description, a definition of it, general average is a principle, as Jimmy says, that dates back to the ancient Greek days. It's a concept. And essentially, it establishes that all cargo, stakeholders, exporters, evenly share in any damage or loss that may occur during the transit of a ship, which may occur as a result of voluntary sacrifice of part of the vessel or its cargo to save the whole vessel. And cargo that in an emergency, that takes place. The principle is that a party who has suffered extreme financial loss in order to save the property of others, as a general average has been stated here, there is a calculation. And each party who has suffered a loss will be credited for the value of the loss and a percentage is to be assessed on all shippers on the vessel. And this is a provision that's normally stated in the Ocean Bill of Lading. And a shipper or owner who is dependent on the terms of sale, it's dependent on the terms of sale, so who the shipper or the owner is, should include this aspect of ensuring their cargo during the transit. That help you?
Yeah, and so this is kind of an unhappy concept in this case even for cargo owners whose cargo ultimately survived.
Yeah.
When the general average is declared, they're going to be looked to contribute to pay for the salvage costs.
Yeah, you're asking the shippers to invest in the safe transit of the vessel.
The idea
So
being,
I'm just going to break in here and say, first of all, I'm gobsmacked by the notion that, pre sort of mechanized, power law is establishing, kind of the legal liability for this particular case. But then even, the last time it was updated was the 1920s by the Supreme Court. So, I mean, we're really talking about kind of the ways that history continues to echo through, our maritime world. And I'm keeping an eye on the time, and I'm loving this conversation, but we have some really wonderful comments and questions from some of the folks in the chat that I think kind of get to the heart of the contemporary, controversies that are swirling around this particular topic. And, and I know so many of us who are affiliated with the center feel, whether you're Baltimoreans or Baltimoreans at heart, feel really personally affected by this tragedy. So I'd like to go over to the Q&A and look at some of these questions from the folks in the group. So people are interested in knowing if anyone, whether the sort of the state of Maryland or those who were killed will ever potentially see any monetary compensation, or will the layers of sort of insurance liability protect the ship owner and the managerial company? What do you think is realistic?
Sure. So the Limitation of Liability Act. So even if limitation is upheld, the Limitation of Liability Act has a special set of provisions that protect personal injury claimants like those who were injured and killed in this incident. It's quite complicated, but as best I understand it, and I haven't actually litigated one of these, but as best I understand it, what the statute does is it says, we're going to give a sort of a super priority or equitably adjust the limitation fund. So the way I understand it works is this: once the dust settles, it's been determined potentially that there's limitation, yet there's not enough money to cover the personal injury claimant's claims. The limitation fund will be increased to a certain value based on the tonnage of the vessel. And that quantum, I think it's $420 a ton, will be set aside, and the personal injury claimant's claims will be the only claims that are able to take from this sort of, I'm going to call it equitable adjustment to the limitation fund. So I believe that even in the event that limitation is upheld in this case, that the personal injury claimants will recover. It's my sense that they will be made whole, I believe, to the extent that the law would typically permit in any event.
That's what happened in that earlier case in the railroad bridge.
Mm-hmm. Yeah.
We have a question here about the timeline and wanting to know what was the role of the crew or captain and the bay pilot in their role in the timeline? So leading up to the disaster itself. And Jimmy, this might be a question for you.
Well, I guess the captain is ultimately in control. The senior pilot is really the one handling the navigation and the control of the ship. I mean, that's what a pilot is for. The pilot is the expert in the bay, in the channel, in the flukes of tide and shoals, and all that. The master of the ship meets with the pilot before they disembark or leave the pier to inform the pilots of any unusual circumstances, any problems. And here, apparently, the captain did not say that there was anything wrong, anything to worry about, which is curious because shortly before this happened, there was an incident on the ship where the power did black out. Now, the reason it blacked out was a crew member apparently made a mistake in a damper of some sort, caused a blackout. It wasn't necessarily a defect in the electrical system, but there will be arguments that the pilot should have been informed of this. As a matter of fact, one of the regulations dealing with it does require the master of the pilot to inform the pilot and to inform the Coast Guard of any unusual instances. And it's got to do that right away, and then he's got to file a form was from 2652, was it?
2692, yeah.
92. Within 5 days. Well, of course, the collision had already occurred at that point, but he never did say anything to either the pilots or to the Coast Guard. So that's going to be an issue. That'll come up.
And the 2692 has sort of, it's a very, straightforward form. One of the things that's listed on there very clearly is a loss of propulsion. What happened alongside the dock was not a loss of propulsion. There's another category, which is more of a catch-all category. When one sort of reads the face of a 2692 form, I don't know that it's necessarily blatant or patent that a loss of the generator because a crew member shut an exhaust damper would necessarily need to be conveyed to the Coast Guard. But then there was a second loss of power alongside, and it also related to a loss of fuel pressure. And so, as Jimmy said, there's definitely going to be a lot of discovery spent over whether these issues were reportable under the 2692 form, and perhaps even to the extent that they may not have been. And there's lots of other guidance that's not on the face of the form about whether something needs to be reported or not. But even if they were not necessarily reportable under the 2692, again, there's going to be a lot of argument about whether that master should have advised the pilot that these things had occurred so shortly before the vessel's departure.
All right, I'd like to, we have just enough time for one more question. So there's a question here. Do you all anticipate that any maritime laws will be changed because of this tragedy? And I'm guessing if it held up through the Titanic, maybe not, but I'd love to hear what the experts think.
Well, we have actually tried to investigate that because any change in the law would probably be statutory and have to go through the United States Congress. We have been digging into that to find out what is going on and whether there would be any bills introduced. There is movement. I do know that when back in the 1980s, when they had problems with the fishermen up in the Bering Strait, there was a lot of political movement to change the law there. I don't think it amounted to much other than requiring a great deal more safety prevention items on the ships. Whether or not the courts will get involved, I don't know. I kind of doubt it.
I don't know. I guess my personal suspicion is that that this may wind up in front of the Supreme Court. There's the congressional route, and Representative Garamendi has actually proposed legislation to limit the ability of ships to limit their liability. And that's currently pending. There was after the conception dive boat, there was a restriction that has to do with it's again, the nuances are a little bit beyond me, but it has to do with certain passenger vessels and of limited size and whether they can limit their liability. So that has happened. That did pass into law. There hasn't been a lot of litigation that I'm aware of over that yet. But the other avenue to change the law, and some of the claimants in this litigation related to this incident have actually asked the court already to change the law. In order for that to happen, for the most part, it would have to happen at the Supreme Court level. My personal take is that we don't have a Supreme Court that is likely to undo Robbins or change the limitation of liability. That's my take on it, just because of the conservative majority.
I would think that the Supreme Court would be more likely to take up Robbins than take up the Limitation of Liability Act. But in today's world where we have so much technology that it lowers the risk You know, we know the weather, we have the GPS, we know navigation, we've got very good equipment. Times have changed. So, you know, you could easily come up with a very good argument that the Limitation Liability Act is now obsolete.
Well, it sounds like there are plenty of people involved in this tragedy who couldn't agree with you more. And I want to thank you, Jimmy, James, and Bill, so much for your expertise and sharing the kind of the complexity behind what seems like a pretty straightforward elision with that is, you know, it turns out it's just as murky as a Patapsco itself.
I live on the shore. It's not so murky.
Oh, right. Yeah, I shouldn't hate on the Patapsco. Patapsco is great.
Bring on the oysters.
Yeah, absolutely.
That's my best. That's my favorite flavor of oyster is the ones that come out of there. Well, thank you all. Thank you so much for your expertise. Thank you, Kate, for your fantastic moderating skills. I know this is like an ever-evolving conversation and learning curve for so many people in the maritime world. Thank you all for your questions. I know we didn't get to all of them because this topic and everything around it is about the size of the ship itself or two of the ship. Like it's just a very big conversation. And I see a couple questions about possibly having a second discussion. We'll see. We're, you know, MCHC will start building our, we might have to have a second one once there is a decision reached. There's our conversations for that. But in the meantime, I'm going to let all of our panelists get back to their evening. I want to thank all of our participants for joining. Again, I want to thank our panelists. Thank you all so much for your time and your brains. This was really fascinating. And this program will be recorded and released on our virtual program archive. And that will be announced via social media and emails if you registered for this event. And yeah. Truly, thank you all. This is a fabulous program. Everybody take care. Have a wonderful evening, and we will maybe see you all in the spring.
All right. Thank you, Chloe. Thanks, everyone. Bye.
Thank you all so much. Have a good one.